I'm a dude now.
What's your name? Come on, Tiffany, let's go.
I know my name.
Tiffany, come on, let's go.
Absolutely not. I'm not leaving. I'm not leaving.
Now you're going to go to jail. Okay? Now you're going to go to jail.
Honey,
Stand
I'm
up.
a lawyer.
Stand up.
You never let someone take you to another. No! You. I want my bag. I want my bag, dude.
Yeah, we're bringing your bag with you. Come on, let's go.
On April 29th, 2023, officers responded to a reported disturbance at an airport terminal. A woman who identified herself as an attorney and former law enforcement officer refused all commands, resisted arrest, and was ultimately charged with resisting arrest and disorderly intoxication. Was the arrest constitutionally sound, or did officers cross a legal line?
I'm speaking to you like men speak to you, and now we're upset.
All right, ma'am, come on. I'm going to escort
Go
you back to
where?
the
I'm not going.
main terminal.
I'm not going.
So you're not going to go?
No. Absolutely not. I will film it, and you can take me wherever you want. Okay, I'm not going. I'm not going anywhere. I paid for my ticket. I'd like to go home. I don't give a shit. I paid for my ticket. I'm a man. I want to go home. I paid for two. No, we're not going anywhere. No, we're not going.
Come on, we're going to go to the main terminal. Come on.
Nope, we're not doing it.
We'll talk to somebody over there. Come on.
No, talk about what?
Let's go.
What are we talking about, though? Okay, what are we talking about, though? Ma'am, you have to stay here with me and witness this. What are we talking about? What did I do?
You needed to, like...
I wanted to go home. I wanted to go on my plane home. Please stay with me, because this is going to be my only witness. I wanted and have paid for 2 plane tickets.
Okay, but you just refunded
to leave. I don't give a about a refund.
Stop using obscenities. Okay?
Would you care about a refund when someone questioned your masculinity?
Okay.
Would someone care about that? Would you say,
Here's
oh, well, I'm a dude now.
What's your name? Come on, Tiffany, let's go.
I know my name.
Tiffany, come on, let's go.
Absolutely not. I'm not leaving. I'm not leaving.
Now you're going to go to jail. Okay? Now you're going to go to jail. Because you don't listen. Don't ever put your hands on me.
Am I going to jail? Because I bought 2 plane tickets.
Hands behind your back. Put your hands behind your back.
Keep recording. Keep recording. This is going to be really fun when you realize. This is going to be really fun when you realize.
Can I have a cage car here, please?
Did I
I'm going to have attempted here.
Anybody, baby, you're gonna be my witness. Did I do something? Was I obnoxious? I just asked questions.
Case number is going to be 23-159-534, again 159.
I'm not selling. I'm not. I don't have a gun, and I'm handcuffed. And I'm gonna handcuff me.
And for you get cage car. Go accommodate.
I did nothing.
Available with a cage car.
You're my witness.
Gate 72.
Baby, I love you. Yes.
71, please.
No, you.
Okay, good.
No, I know. I'm a huge criminal. Thank God you got a perp. Thank God you got a big perp. I have a big dick too, bitch. You want to see it?
Good.
Go accommodate you with a cage car.
For real? I'm just trying to leave the city. I paid for 2 plane tickets. Yeah, there's nothing.
Go 280 Alpha.
Duh. And I'm losing him. You cocksucker.
And for you available.
Losing him, you cocksucker. I'm not guilty as shit. No. People, white people, black people, brown people are allowed to hear what happens in an airport.
Steve.
We out of gate 71.
I'm not going anywhere.
Can you open this up for me and bring her?
I'm not going
here. I gotta bring her downstairs.
Just
bring the suitcase for me, please. Come on.
Please tell me with your phone. No! You!
with you. Come on, let's go.
Off!
280. Can you come up to the brace for me, please?
I got your bag right here, miss.
Come on. Stand up.
Honey,
Stand
I'm
up.
a lawyer.
Stand up.
You never let someone take you to another position. You're gonna really regret this when I get home, sweetheart. I'm playful. You're really gonna regret this decision, though. You need to let these off. I'm not a problem, dude.
Come on, stand up.
I've never been a problem. Let me off. Let these off.
Alright, you gotta stop. You have to
Stop what?
Just
Stop what?
We're ready, we're gonna stand up.
Come on, stand up. Put your shoes on.
Put your shoes on. Alright?
Officer 9, do you have the age of passenger for
About 40. About 40.
Yeah, I know how to do that, sweetheart.
Let's walk.
Oh my god, really? Actually, this will be excellent.
Transfer level.
I didn't ask for it.
What did I say to you other than...
Oh,
What did I say to you? No! What did
I
I
just needed help just bringing her down because she's just laid down on me.
Of course I'm gonna lay down. I'm a lawyer. Of course I'm No!
We don't want your phone.
We don't need our...
No! Go first! You go first!
Come on. Walk down. You got that Bible?
You know what? I'm so mad at all of you boys. I was a sheriff in southern Minnesota for so many years, and everybody hates me. I was law enforcement for a long fucking time in here. I didn't kick you.
I said do not kick. I didn't say do not kick me, okay?
I didn't pat her down because I don't have...
That's all right.
Grab me down.
Take that out.
Dude, there's not a gun. There's
Squall
nothing.
comes, okay?
There's nothing.
Let me just check real quick, ma'am. I want to make sure there's no
I
weapons.
just want to go
Stand
to
still.
my plane. I just want to go to my plane.
Got it. Thank you. Just put it front, ma'am. Have a seat in the back. You look like you don't have any weapons on you. Go ahead, sit down.
Have a seat.
Watch your head. Head first. You're going in, ma'am.
I want a lawyer. I'm not getting in the car.
Watch your head.
I'm not getting in the car.
Stop resisting. Put your feet in the car.
I'm not getting in the car until my lawyer is here. I'm not getting in the car until my lawyer is here. You know what?
All right, I'm going to get in.
Where's my mask? Where's my
It's over here. Relax. Directing like a child. Stop it.
You're acting like a child.
Come through. Hello. Yeah, so just check her out. She's intoxicated, and there was a altercation with her and the officer. Officer was battered, and so just wanted to look at both of them, just so that way you can give us the okay. That's it. Ma'am, hold on.
You have no PC.
Hold on, ma'am. Stay in the car. Hey, we're not gonna do this. Just give me a second, okay? This is the airport rescue and firemen, okay?
I understand.
All right, they're
I
gonna.
also have a law enforcement degree. I'm also an attorney. I do understand what's happening, and I'm a little
Are
frustrated.
you in any need of medical, ma'am?
No. No.
Do you need them to
I'm
look at
drunk.
you?
Just like you guys get drunk. I'm drunk.
I got it. You're drunk. Okay. Is there anything else?
No.
Okay. Well, I guess she doesn't need you to look at her. This is the officer. Stay in the car, ma'am. Stay in the car, ma'am. Stay in the car, ma'am.
All right. Come and check, boys.
All right.
You know, I used to and teach. I used to train for Mankato State in law enforcement. And y'all are doing a good job, but you missed the wrong thing. I lost my shit because the flight was late. And I know no way.
So you don't need any medical, you're good. Okay.
I'm fine. I've always been fine.
He's good. As long as you came and we're good.
Cups on me.
Appreciate you guys. All
I
right.
had it.
Ma'am, get back in the, put your feet back in the car, please.
No. I want to
Stop
see it.
resisting,
No,
ma'am.
I'm
Stop
not.
resisting.
It's not resisting.
You are. I'm giving you a lawful command to put your feet back in the vehicle, okay?
Yeah, I hear you.
You understand what's going on? We are not going to fight.
I have a law enforcement degree.
We are not going to fight, ma'am.
I'm not absconding with you, and I'm not with you. Having my legs out of a car
Thank you, ma'am.
isn't enough.
Now, let's break down the legal analysis. The initial detention stands on solid ground under Terry v. Ohio 1968, which requires only reasonable, articulable suspicion. A reported public disturbance at a busy airport terminal satisfies that threshold. As the encounter escalated from a voluntary contact to a directed detention, it triggered full Fourth Amendment seizure protections, placing a higher burden of justification on officers with each step forward. Building on that foundation, the disorderly intoxication charge is addressed directly by Florida Statute, Section 856.011, which requires only that a person be intoxicated in a public place and cause a public disturbance. Violent conduct is not an element of this offense. The subject's sustained, loud refusal at a high-traffic airport gate independently satisfies this standard. Turning now to the use of force at the moment of handcuffing, Graham v. Connor, 1989, is the controlling standard. Force is judged from the perspective of a reasonable officer on the scene, not in hindsight. Applying soft restraint to a verbally resistive, intoxicated subject in a public terminal is proportional and legally defensible under that test. On the question of the subject's profane language, City of Houston v. Hill, 1987, is unambiguous. Offensive and vulgar speech directed at law enforcement is protected under the First Amendment. The narrow fighting words exception established in Chaplinsky v. New Hampshire, 1942, requires a direct provocation, likely to cause an immediate breach of the peace. Insults alone do not meet that bar. Any arrest predicated solely on the subject's language would not survive constitutional scrutiny. Yet the subject's reliance on passive resistance as a legal strategy has a critical statutory limit. Florida Statute Section 843.02 makes it a first-degree misdemeanor to resist or obstruct an officer in the lawful execution of a legal duty, without any requirement of violence. Refusing to stand, lying on the floor, and extending legs from the patrol vehicle each independently satisfy this statute when the underlying arrest is lawful. Passive resistance is not a constitutional shield. Under Florida law, it is itself a criminal offense. Perhaps the most legally significant moment in this footage is the subject's explicit statement, "I want a lawyer. I'm not getting in the car." Under Miranda v. Arizona, 1966, an unambiguous invocation of counsel while in custody requires all interrogation to cease immediately. Officers completed the arrest and transport without further questioning. That is legally correct. Equally important, the subject's spontaneous statement that she lost her shit because the flight was late was made without any interrogation. Under Rhode Island v. Innis, 1980, voluntary, unprompted disclosures in custody are fully admissible. Miranda does not apply. Rounding out the legal picture, officers summoned Airport Rescue and Fire for a pre-transport medical evaluation, a decision that reflects both professional best practice and sound liability management. One officer reported to medical personnel that the officer had been battered. If physical contact by the subject is established, the exposure elevates to Florida Statute Section 843.01, battery on a law enforcement officer, a third-degree felony. Finally, the officer's precise command, "I am giving you a lawful command to put your feet back in the vehicle," creates a clean evidentiary record of deliberate noncompliance, materially strengthening the resisting charge. With the legal framework in place, it is time to evaluate the parties. The primary officers receive a B. Force was proportional and consistent with Graham v. Connor. Pre-transport medical clearance reflects professional best practice, and officers correctly ceased questioning after the Miranda invocation. However, deductions apply. Referring to the subject as acting like a child is unprofessional and legally unnecessary. More substantively, a structured de-escalation attempt, before physical restraint was available and not fully utilized. An omission that, while not unlawful, reflects a missed opportunity to resolve the situation with a stronger overall record. The subject receives a C+. She correctly invoked her right to counsel and understood the legal distinction between passive and violent resistance, both informed choices, yet her prolonged passive non-compliance independently established probable cause under Florida Statute Section 843.02. Her voluntary admission of intoxication is potentially admissible, and if battery on an officer is proven, her exposure reaches felony level. A subject with demonstrable legal knowledge, whose judgment was ultimately overridden by intoxication, turning a manageable situation into a criminal matter of her own making. This case carries lessons that extend well beyond the terminal floor. For law enforcement, de-escalation is not a tactical concession. It is a legally protective instrument. A documented verbal de-escalation attempt strengthens the arrest record, reduces force liability, and as this encounter illustrates, may resolve a situation before restraint becomes necessary at all. For citizens, the distinction matters more than most realize. Invoking the right to counsel is constitutionally correct, but passive resistance, however legally framed, is a separate offense under Florida Statute Section 843.02. Knowing your rights and exercising them strategically are not the same thing, and intoxication closes that gap quickly. And for both parties, perhaps the sharpest lesson here is the one Miranda itself never fully taught. Voluntary statements made in custody carry the same evidentiary weight as any other admission. Silence is the only constitutionally protected default. Explanation, however honest or sympathetic, is not. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.